All right, Unit 3, Part 5. Let's carry on. Payments of contributions to a medical scheme. Section 26, subsection 6 and subsection 7 of the Act stipulate that no person other than an employer shall receive, hold, or in any manner deal with the subscription or contribution which is payable to a medical scheme by or on behalf of a member of such medical scheme, and all subscriptions or contributions shall be paid directly to a medical scheme not later than 3 days after payment thereof becoming due. So you need to pay ASAP, but no later than 3 days after the payment becomes due for payment. The reason why it is so vital to ensure that contributions are paid timeously to the scheme is that the interest they earn on all those contributions that can be earned from the contributions, this can be considered for a large group of members. So let's say they've got 6,000 members, and it's the contributions. You can imagine the money that must come in. I don't know. Let's take a figure. 200 million rand. What is the interest they can earn on that money? Let's say the interest on that 2 million, I'm just taking figures for example, is 50,000 rand. That's an extra 50,000 rand that month that the medical scheme has to pay for other things. If they get that for a year, for 12 months, that's an extra 600,000 rand interest that the medical aid had. That can help a lot of people. So without touching their money, they use that 600,000 interest they've earned over the year to pay most of the things. And once that is finished, then they start touching their money. Okay. So let's read the sentence again. The reason why it's so vital to ensure that contributions are paid timeously to the scheme is that the interest that can be earned from the contributions, and this can be considered for a large group of members, as we said, for instance, that 6,000 members, sitting in the bank account of an entity other than the medical scheme constitutes a loss to the scheme. So if everybody pays late, they lose that interest. It's money gone wasted. Some medical schemes require the payment of contributions in advance, so they want you to pay upfront, while others require payment in arrears. It depends from medical scheme to medical scheme. It is essential to be aware of this fact when ensuring that contributions are paid timeously to the scheme, especially when a new member joins. If contributions are payable in advance, in other words, upfront, then the first contribution is payable at the beginning of the month. So that you can be upfront when the member joins the scheme. Whereas if the contributions are paying in arrears, in other words, at the end of the month, so you first get the enjoyment and then you have to pay, then the first contribution is payable at the end of the first month of membership. In terms of Rule 13.2 of the Model Rules, contributions are payable monthly in advance and are payable not later than the third day of the month. Where the contribution is 30 days or more overdue, in other words, you fall behind, the scheme shall have the right to A, to suspend all your benefit payments in respect of claims which arose during the period of default. B, to give the member written notice at his or her domicilium citandi et executandi, and that's just a legal Latin word for your physical address, that if contributions or such other debts are not paid within 21 days of the posting of such notice, membership may be cancelled. All right. This rule is in terms of Section 29, subsection 2 of the Act, which provides for a medical scheme to cancel or suspend a member's membership where there is a failure to pay within the time allowed in the medical scheme rules, the membership fees required in such rules. In the event that payments are brought up to date and provided membership has not been cancelled, Rule 13.3 of the Model Rules provides that benefits shall be reinstated without any break in continuity, subject to the right of the scheme to levy a reasonable fee to cover any expenses associated with the default and to recover interests on the arrear amount at the prime overdraft rate of the scheme's bankers. If such payments are not brought up to date, no benefit shall be due to the member from the date of default, and any such benefit paid will be recoverable by the scheme. So you see, if your payments are brought up to date, everything shall be reinstated without the break in continuity, and then you can carry on. As you must also be careful. Now you've got the medical aid, you fall behind on premiums. If you don't pay, then they will cancel the membership. And if there's a 3 month break and you get money again and you join another medical scheme, they will say you had a break for more than 90 days or more than 3 months, and you might be able to pay a late joiner penalty. So make sure that that doesn't happen. The Moral Rules, Rule 13.4, also provide that when membership terminates before the end of the month, no portion of the contribution paid in respect of that month is refundable. The Act requires that the medical scheme shall keep all money and assets belonging to a medical scheme, and every medical scheme or the administrator, as the case may be, shall maintain such book of accounts and other records as may be necessary for such medical scheme. Therefore, no third party, not even the scheme's administrator, is permitted to hold in its name assets or money belonging to the scheme. In terms of Section 26, subsection 1 of the Act, a medical scheme must establish a bank account under its direct control into which shall be paid every amount 1. Received as subscription or contribution paid by or in respect of a member, and 2. Received as income, discount, interest, accrual, or payment of whatsoever kind. The timeous payment of contributions is critical to healthy cash flow for the scheme, since it's paying out a great deal of money every month to providers of healthcare services in respect of claims by beneficiaries. The late payment of contributions can seriously prejudice a medical scheme and will ultimately impair its ability to operate. So, what is the rules concerning payments of benefits by a medical scheme? Regulation 6 of the regulations to the Act provides for the manner of payment of benefits. In terms of Regulation 6, subsection 1, a medical scheme must settle a claim submitted before the end of the 4th month after the beneficiary concerned received the last health service stated on the account. So, the medical scheme must settle your claim submitted before the end of the 4th month after the beneficiary concerned received the last health service statement on the account. Okay, so they've got 4 months to settle that. And that is why some doctors moan and complain they only get their money 3 or 4 months later. And in the meantime, they'll have to live on the overdrafts, and they really suffer. And then when they go into the overdrafts, I know, got inside information, if they go into the overdrafts, the banks are hitting them with interest. Then they cry all the way. And then 3, 4 months later, the medical schemes pay them. Then they get settled the overdrafts. They just out of it, or sometimes still in it, because of the interest the bank charges. So yes, it's a constant fight, and that's why the medical schemes can negotiate lower rates, as we said yes at the previous part, and then they'll go for lower premiums if they get the money quicker. Similarly, where an account or claim has been returned for the correction and is resubmitted before the end of the 4th month after it was returned, it must also be paid. So if there was any discrepancies and the corrections and they had to resubmit, then also it needs to be paid within that 4 months after it was returned, after the correction, etc., to be paid. So this regulation does not mean that a medical scheme cannot pay a claim submitted later than the end of the 4th month after the beneficiary received the last service. It merely means that the scheme cannot refuse to pay claims submitted within the 4 months. They have to pay it when they received it within that 4 months. So whether they send it away for corrections and this, the point is they've received it in that 4 months. The 4th month rule does not apply to claims by providers against patients for payment for health services, as such claims will only expire after 3 years in terms of the Prescription Act. Our Prescription Act in law says that if you've got an issue with something and you don't give any attention to it or you don't do anything about it, after 3 years it prescribed. In other words, it's cancelled, it falls away. So, for an example, if you lend money to your friend, let's say 1,000 rand, and you start asking him, listen, I want my money. When do I get my money? You said end of the month I get my money. And you keep on promising. And he said, yeah, whatever. And then you leave it. If you do nothing about it for the next 3 years, and then after 3 years, you decided, hang on, that guy still owe me 1,000 rand from more than 3 years ago. And you go at him and again, he can tell you it prescribed. I don't have to pay you. You can go and see a lawyer. The lawyer are going to tell you, but when last did you speak to him about it? Before now. He said, no, more than 3 years ago. Your lawyer will tell you, because you didn't act in that 3 years. The prescription says, such claims will expire after 3 years. That is what the law says. So there's nothing that no lawyer or advocate can do for you. You left it for 3 years, it expired, and you can do nothing. So don't let 3 years go by without doing nothing. Rather harass that person once a year or every 2 years. Then you can tell your lawyer, no, last year I reminded him. Oh, so there wasn't a 3-year gap. No. Why? Then it doesn't expire. The moment there's a 3-year gap, it's gone. Many healthcare providers do not release their patients from liability for the payment of health services simply because they are beneficiaries of a medical scheme. Therefore, members can still be held liable for the payment of invoices for a period of up to 3 years after the health service was rendered. So, yes, you don't pay at the hospital, you walk out, you said, no, the medical aid will pay, and you go home. But now your medical aid doesn't pay, they've got this issue, that issue, or they go bankrupt, they close their business, their doors. You are still liable to pay for the next 3 years. So you must better hope and pray that your medical scheme pay. Most of the cases they do. But this is just rules that's there in place for in case there is an issue or a problem. A member of a medical scheme can, therefore, find him or herself in a situation where the scheme refuses to pay a health service provider's bill because it was submitted after the 4th month deadline, and the provider demands payment from the member. So you had an operation or something that the hospital said, fine, now we'll put it through your medical scheme. or they give you the invoice if you see the doctor, and then you don't give it to the medical aid. And after 5 months, you realize, oh my goodness, I forgot it. I'm going to submit it now. Then I says, no, 4 months expired. Sorry, we're not paying for it. You know the rules. So then you have to pay for it. So make sure that they do get their bills. Phone them every month. Did you get my bills? Make sure. I'm doing the same. I'm following up. Listen, I've sent you this bill. Will you please pay it? The last one I did was they had to cut something small out of my leg. And I sent that bill. It was 1,600 rand. I sent it to my medical scheme, and then I followed up. When I sent it, I said, please reply back to me to confirm that you've received it. So I got the email back. Thank you very much for the invoices. We did receive it. We will get back to you once we made a decision. And I waited and I waited and I put the reminder on my phone. I give them 1 week, then I'm sending another email. And 5 days later, I got the email back. Said, listen, it's being processed for payment. And once they've paid it, I got an email, your account has been paid. Then I followed up on the daycare hospital. They said, no, thank you. They've paid it. So now I know it's paid. Confirmation from my medical scheme, confirmation from the doctor's practice and with the daycare hospital. So I'm okay. According to Rule 15.3 of the Model Rules, in order to qualify for benefits, a claim must, unless otherwise arranged, be signed and certified as correct and must be submitted to the scheme not later than the last day of the 4th month, following the month in which the service was rendered. It could therefore be argued that the legal liability of the medical scheme towards the member will lapse in the absence of an alternative arrangement at the end of a period of 4 months after the month in which the health service was rendered. However, the claim of a medical scheme member against a medical scheme is a debt of the scheme, and therefore it could be argued that a medical scheme's obligation to pay claims may extend beyond the 4th month allowed for in the scheme rules. The tariff and billing practices. So Section 29, subsection 1Q of the Act requires a medical scheme to make the payment of any benefits according to 1. A scale, a tariff, or a recommended guide, or 2. Specific directives prescribed in the rules of the medical scheme. The Competition Commissioner has ruled per the Competition Act that the collective negotiation of tariffs between medical schemes and providers of healthcare services is anti-competitive. So they want it to be the same. They don't charge one medical scheme more and the other one less. It is a very simplistic view of competition within the health sector and has been proven over time to have had the effect of driving prices up instead of down, as the Competition Commission had expected. So, however, the law is still such that no two or more medical schemes or providers of healthcare services may agree together on what to pay or charge for healthcare services. Following the ruling of the Competition Commission, the Department of Health took over the responsibility for publishing the National Health Reference Price List, the NHRPL, a list of guideline medical tariffs. However, in 2010, a ruling of the North Gauteng High Court declared the NHRPL null and void. So they cannot use that anymore. This ruling effectively took away the only reference guideline available to medical schemes for setting the level of reimbursement of claims to service provider. In the current environment, each medical scheme is required to set its own scale or tariff at which it will pay any benefit provided for under the rules of the scheme, except for the prescribed minimum benefits which have to be paid in full according to Regulation 8, subsection 1 of the regulations of the Act. So when you look at complaints and appeals, Chapter 10 of the Act makes provision for a comprehensive system of complaints and appeals from decisions of a board of trustees, the registrar of medical schemes, and even the council for medical schemes, the CMS. A complaint with regards to any matter provided for in the Act may be lodged in writing with the council of medical schemes. Remember, not telephonically, in writing. The registrar is obliged to notify the party against whom the complaint is made. So the client will complain, and then the registrar must inform that medical scheme. Your client has complained against you. The registrar must, as soon as possible, after receipt of any comments furnished to him, in other words, any claim furnished to him, either resolve the matter. Comments, it might be from both parties. So then, if he received the complaint from the client, he informed the medical scheme he has received it. The medical scheme will reply with their comments, and after he received it, he can decide either to resolve the matter or to submit the complaint together with such comments, if any, to the council. The council must then take all necessary steps as may be deemed necessary to resolve the complaint according to Section 47. In terms of Section 48, any person who is aggrieved by any decision relating to the settlement of a complaint or dispute may appeal against such decision to the council. The operation of any decision which is the subject of an appeal under subsection 1 shall be suspended pending the decision of the council on such appeal. An appeal must be in the form of an affidavit directed to the council. It must be furnished to the registrar not later than 3 months of such further period as the council may, for a good cause shown, allow after the date on which the decision concerned was made. So if they made a decision and you're not happy and you want to appeal, it must be sent to the registrar not later than 3 months. Otherwise, you cannot appeal anymore. So, A. In writing, request any person who may be able to give material information concerning the subject of the appeal or who has in his or her possession any document which has any bearing upon the subject of the appeal, to appear before it at the time and place specified in the written request, to be examined or to produce that document, and may retain for examination any document so produced. So if you bring them that document, they can keep it until the court case or the decision case has been settled. Be administered on an oath to or accept an information from any person called as a witness at the appeal, and C. Call any person present at the hearing of the appeal as a witness and examine him or her and require him or her to produce any document in his or her possession or custody or under his or her control. The procedure at the hearing of an appeal is to be determined by the council, so that it will determine the procedure, how things will work. The council may, after hearing the appeal, confirm or vary the decision concerned, or rescind it and give such other decision as it might deem just. The decision of the council must be in writing, and a copy must be furnished to the person appealing. Section 49 states that any person who is aggrieved by any decision of the registrar under a power conferred or a duty imposed upon him or her by or under the Act, excluding a decision that has been made with the concurrence of the council, may, within 30 days after the date on which such a decision was given, appeal against such decision to the council, and the council may make such order on the appeal as it may deem just. In Section 50 of the Act, provision is made for the establishment of an appeal board consisting of 3 persons appointed by the minister, of whom A. One shall be a person appointed on account of his or her knowledge of the law, who shall be the chairperson, and B. 2 shall be persons appointed on account of their knowledge of medical schemes. So the appeal board will consist of 3 people, which one person must have knowledge of law, and the other 2 persons must have knowledge of medical schemes. And they will make up the 3 persons. One with law knowledge and 2 of medical scheme knowledge. Law times 1, medical scheme knowledge times 2. And that will be your 3 people. If that makes better sense to you. Any person aggrieved by a decision of the registrar acting with the concurrence of the council or by a decision of the council under a power conferred or a duty imposed upon it by or under this act may, within a period of 60 days after the date on which such a decision was given, and upon payment to the registrar of the prescribed fee, appeal against the decision to the appeal board. So if you're not happy and you're not satisfied with this decision of the council, you may appeal it, but within a period of 60 days. Any person who lodges such an appeal must submit with his or her appeal written arguments or explanations of the grounds for his or her appeal. Why do you want to appeal it? The chairperson of the appeal board determines the procedure at the hearing of an appeal. And that is the end of this unit. If you've got any further questions, please feel free to ask me, and I'll see you in Unit 4.